Our study of evidence suppression begins where the underlying right is found, the Fourth Amendment to the United States Constitution. This amendment protects citizens against unreasonable searches and seizures. It states, in part, that the right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated. When this right is violated by law enforcement, the primary judicial response is the exclusionary rule. It is crucial to understand the dual purpose of this rule. First, it serves as a deterrent, aiming to discourage future police misconduct by removing the incentive to violate constitutional guarantees. Second, it upholds judicial integrity, ensuring that courts are not complicit in lawbreaking by admitting evidence obtained illegally. Note that the exclusionary rule itself is not explicitly written into the Constitution. Rather, it is a judicially created remedy designed to enforce the Fourth Amendment guarantee. We will now define this remedy more precisely. Now we define the exclusionary rule precisely. At its core, this rule mandates that evidence obtained by law enforcement in violation of a defendant's Fourth Amendment rights must be excluded from the prosecution's case in chief during a criminal trial. This is not a universal bar. It specifically targets the primary evidence used to prove guilt. The rule's journey began at the federal level with the landmark 1914 Supreme Court decision, Weeks v. the United States. For decades, this protection only applied federally. The critical expansion occurred in 1961 with Mapp v. Ohio. Mapp incorporated the Fourth Amendment protections against the states through the Due Process Clause of the 14th Amendment. Therefore, the exclusionary rule now applies to both state and federal prosecutions. Remember, the remedy is exclusion from the main case, preventing the government from using the illegally obtained items to secure a conviction. Having established that the exclusionary rule applies to both state and federal criminal trials, we must now examine its precise scope and limitations. First, the rule is a check on governmental power. It applies exclusively to evidence obtained through the actions of government agents, such as police officers or federal investigators. Evidence obtained by private citizens acting on their own initiative is entirely outside the purview of the Fourth Amendment and the exclusionary rule. Furthermore, the rule has significant procedural limitations. It does not apply in several non-criminal contexts. Specifically, evidence obtained illegally is generally admissible in grand jury proceedings, civil trials, administrative hearings, and deportation hearings. While the Mapp decision ensured the rule applies to state criminal trials, these procedural exceptions remain consistent across jurisdictions, focusing the exclusion remedy strictly on the prosecution's case in chief in a formal criminal proceeding. We have focused on evidence seized directly during an unconstitutional search. But what about evidence discovered later, as a result of that initial illegality? This brings us to the crucial extension of the exclusionary rule, the fruit of the poisonous tree doctrine. This doctrine was firmly established by the Supreme Court in the landmark case, Wong-Sun v. the United States. Think of it visually. The initial illegal search or seizure, the Fourth Amendment violation, is the poisonous tree. Any evidence subsequently obtained because of that initial violation is considered the fruit. If the tree is poisoned, everything that grows from it is also tainted. For instance, if police illegally enter a home and find a diary, and that diary leads them to a hidden stash of drugs, both the diary and the drugs are the fruit. Our next step will be examining the necessary connection required for this doctrine to apply. To apply the fruit of the poisonous tree doctrine effectively, the prosecution must establish a clear link between the initial Fourth Amendment violation, the poisonous tree, and the evidence sought to be excluded, the fruit. This link is often described in terms of taint. If the initial illegality taints the subsequent discovery, the evidence is inadmissible. The core requirement is demonstrating a direct causal relationship. The evidence must be the product of the illegal act, not merely discovered afterward by coincidence or through unrelated means. Not every piece of evidence discovered after an illegal search automatically becomes fruit. The connection must be sufficiently close in time or logic. If the chain of causation becomes too attenuated, or if an intervening event purges the taint, the evidence may be admitted. Understanding this necessary causal connection is vital because it sets the stage for the primary ways the defense can attempt to suppress evidence, and conversely, how the prosecution can argue that the taint has been removed. We will now explore the primary doctrines that break this chain of taint. We just established that the prosecution must prove a direct causal link, the taint, between the initial Fourth Amendment violation and the evidence. However, this chain of taint is not unbreakable. The first major exception that allows evidence otherwise tainted to be admitted is the independent source doctrine. This doctrine applies when the evidence is also obtained through a source wholly independent of the initial constitutional violation. Think of it this way. If the police could have lawfully obtained the evidence anyway, the initial illegal conduct does not require suppression. For instance, imagine the police conduct an illegal search, but before that search, they had already secured a valid search warrant based on untainted information. If the evidence found during the illegal search matches evidence found pursuant to that pre-existing, lawful warrant, the evidence derived from the lawful warrant is admissible. The key is that the lawful source must be truly independent, meaning the illegal search did not inform or assist in obtaining the evidence from the independent source. This doctrine prevents the exclusionary rule from achieving a windfall for the defendant when the police were already on a lawful path to the evidence. Moving beyond the independent source doctrine, we encounter the second major exception to the fruit of the poisonous tree rule, the inevitable discovery doctrine. This doctrine is rooted in the idea that if the prosecution can prove by a preponderance of the evidence that the evidence would have been discovered inevitably through lawful means, then exclusion is unnecessary. Unlike the independent source doctrine, which relies on an existing, separate lawful path, inevitable discovery focuses on a hypothetical future path that was already set in motion. Consider a scenario where police illegally search a warehouse, but simultaneously, a massive, lawful search party, already organized before the illegal entry, was closing in on the exact location of the contraband. If the prosecution can show that this proactive, lawful investigation would have uncovered the evidence regardless of the initial illegal entry, the evidence is admissible. The key distinction here is the focus on the proactive, lawful investigation that was already underway, ensuring the exclusionary rule does not suppress evidence the government was destined to find lawfully. We now turn to the third, and arguably the most critical exception for bar examination purposes, the good faith exception, cemented by the Supreme Court in the landmark case of United States v. Leon. This exception addresses situations where evidence is seized pursuant to a search warrant that is later determined to be invalid, perhaps because it lacked sufficient probable cause. The core principle is this: if the police officers executed the search while reasonably relying on the magistrate's authorization, the evidence obtained is admissible. The exclusionary rule exists to deter deliberate or reckless police misconduct, not honest mistakes made by judicial officers. Therefore, if the officer had an objectively reasonable belief that the warrant was valid when they executed it, the evidence stands. There are limited circumstances where this exception does not apply, such as when the affidavit supporting the warrant was so lacking in probable cause that no reasonable officer could have believed it valid, or if the warrant was facially deficient. Furthermore, Good faith can extend to reasonable reliance on statutes later declared unconstitutional, or reliance on clerical errors made by court employees. We conclude our discussion of exceptions with a vital limitation on the scope of exclusion, the impeachment exception. Even if evidence, whether obtained directly or as fruit of the poisonous tree, is suppressed from the prosecution's case in chief, it retains utility. Specifically, if the defendant chooses to take the witness stand and testifies contrary to the facts established by that suppressed evidence, the prosecution may introduce the otherwise inadmissible evidence solely to challenge the defendant's credibility. This is not for substantive proof, but purely for impeachment purposes. This exception underscores a key tension in Fourth Amendment jurisprudence. Ultimately, the Supreme Court constantly navigates a delicate balance. On one side, we have the imperative to deter serious governmental misconduct and protect constitutional privacy rights. On the other side, there is the fundamental need to ensure that the criminal justice system convicts the factually guilty based on reliable evidence. These doctrines, and their numerous exceptions, represent the court's ongoing attempt to strike that precise equilibrium.